order. Oftentimes, if I'm not ready right at 10:30, it's because other legislative business is happening in our 9:30 committee. So apologize for a little bit of a late start, but rest assured that we're all working. Thank you for the continuation of yesterday's hearing today. Again, we didn't have time to fully hear from all our conferees on both sides of the issue, so we're setting aside another day of hearing to hear the other side, to hear from our opponents of the bill. So with that then, I will first ask a request for bill introductions. Do we have any requests for bill introductions? Senator Corson.
Thank you, Madam Chair. I have one bill request. It's RS 1061, increasing the penalty for battery committed against a utility worker.
Any objections to the bill introduction? Seeing none, the bill is so introduced. Any other request for bill introductions? Seeing none, then we will reopen, or I guess continue the hearing on Senate Bill 57, and note for the public that several of our committee members are appearing on WebEx today. However, pursuant to rules of the Senate, that unless they are in the Capitol building on WebEx, they won't be able to ask questions of the conferees, but they will be listening and will have your written testimony, and we'll be following along that way. So with that then, I would invite Ms. Jessica Glendenning, Kansas Association of Criminal Defense Lawyers, to the podium. And please make sure for all our conferees that when you speak at the podium, you speak directly into the microphone. If you're turning to look at committee members, which is often the temptation as we're answering and asking questions, those online can't hear you. So with that, please introduce yourself and welcome to committee. And make sure the microphone is turned on. Great, thank you.
Thank you. And I appreciate you coming back today to give us a chance to be heard on this bill as well. My name is Jessica Glendenning, and I am a current public defender here in Shawnee County, just a block down the road. I have previously worked as a public defender for many years in Johnson County and in private practice in Douglas County and several of the surrounding counties in northeast Kansas. I'm here on behalf of the Kansas Association of Criminal Defense Lawyers to talk to you about why this current bill is not a good solution to this problem, just as I have told the County and District Attorneys Association members. We are being presented here with a false dichotomy that either we pass this bill as presented or people who are accused of terrible crimes will go free. I'm not asking you to do nothing. I am here asking you to pass a bill that will fix this particular problem and not create new ones. We absolutely agree that there are a number of cases piling up in counties because we are not able to try jury trials right now. We disagree about how we should address that problem. I have been speaking with the bill's proponents, and I think we may be able to find a more nuanced proposal that addresses this issue as well as our concerns. So first and foremost, I would like to ask that you give us a little bit of time to work on a better solution. But in the meantime, I want to explain to you why we have concerns about the bill as it is proposed. There are two proposed subsections that I wanted to talk to you about today. The first one is Subsection J, which would suspend speedy trial until May of 2024. And then also Subsection K, which would abolish the statutory speedy trial provisions forever in the state of Kansas. So Subsection J proposes that we suspend speedy trial for 3.5 years. As the proponents noted, we have no idea how this pandemic is going to play out. This time last year, we never would have guessed that we would still be dealing with this issue today. And it may be that this goes on for years, or it may be resolved within a matter of months. So our concern is that a blanket extension of 3.5 years does not actually pass the test for a constitutional speedy trial. You heard a lot of talk yesterday, I think, about the differences between the constitutional speedy trial provisions and the statutory speedy trial provisions. Passing this bill would not relieve the state of its duty to bring defendants to trial in a speedy manner. It just removes the clear definition of what speedy is. If this bill is passed, the courts and the parties are likely to rely on this language. If they do that without making proper findings about the current state of conditions in their district, they may very well be violating constitutional speedy trial. This could result in future dismissals for violation of constitutional speedy trial, even though it was within the time frame of the statutory speedy trial if this bill were passed. It could also result in defendants sitting in jail for longer than necessary. We have proposed some additional language in our written testimony, and our language would allow the courts, the district courts, to make findings about the court's calendar, either that the current conditions don't allow the case to be tried in a safe manner, or that the trials cannot currently be conducted because there are too many cases on the docket. It would allow for as many extensions as the court needs, but it requires specific findings in order to make those extensions. So it would give the courts flexibility to extend speedy trial in individual cases for as long as it is needed in that specific jurisdiction. It would just require specific findings. That would ensure that defendants are getting into court, that the court is saying, this case is important, but we can't get it to trial right now, and they make a record of why. That would ensure that it would withstand a later review for constitutional speedy trial, but it would still allow extensions as needed. It would require a brief hearing where the district court would make findings on those current conditions. Right now, cases that are set for trial are not just sitting in jail with no court hearings. We're being called into court periodically to check in and essentially establish the status of the case. Are we able to move forward? If not, why? And where do we go from here? So this is not going to impose an additional burden. It would just ensure that when we have those hearings, the court makes a record of this is how many cases we have, and this is where you are on the list, and this is why we can't get you to trial right now, or the conditions in our community are such that we can't proceed safely. It's not going to create extra hearings in most cases, because those cases can't just languish without a hearing. They are being called into court. This would just ensure that the court is making findings at those hearings. So it would not impose a major burden on the court system. I've confirmed with people in several other jurisdictions that that is how cases are being handled there. Mr. Howe told me yesterday that the courts in Johnson County are already doing this, essentially. Although right now they are just making findings that the governor's order has suspended things. I don't know if they're making additional findings beyond that, but some of this is already occurring, at least in some jurisdictions. If we modified that proposal and we accepted a version where the courts have to make specific findings, that's not going to result in dismissal of cases. In fact, it's ensuring the opposite. It would be far less likely that cases would be reversed later, and it would still give the courts the flexibility to extend things as needed. In speaking with Mr. Bennett yesterday, I think he had an alternate idea that would incorporate findings like that by the court, but would also allow an extension up through 2024. And I don't necessarily think that's a problem. So I think that we can find something, a way to craft language that would incorporate all these concerns. I think our proposal actually would give the courts the ability to extend beyond 2024, which if the pandemic continues and things are not able to be tried by 2024, the current proposal, they'll have to come back and ask for another bill to modify that language. So I think that more flexibility is actually better in this scenario. So this is not a choice between accept the proposed language in Senate Bill 57 or let people accused of serious crimes go free. But this leads me to the second subsection in 57, which is Subsection K, and it proposes to eliminate statutory speedy trial completely. This provision is not tied to the current backlog of cases. It is essentially a proposal that would dismantle the system that has existed in our state since its inception. Now, I know Senator Corson asked Mr. Bennett yesterday about when this statutory provision first arose, and Mr. Bennett said it was codified in the 1960s. And that is true in its current form. But this right has existed since our state was formed. In the general laws in 1862, there was a provision that said speedy trial meant within 2 sessions of the district court, because the courts were not in session all the time, so you had 2 sessions where the court would be in session to get someone to trial. It has evolved over time as our court systems have changed, but it has always been codified in our statute, a bright line rule as to what speedy trial meant. Without that statutory right, defendants have no way to exert pressure on the state to try its case. I testified on the House version of this bill last week, and I heard Mr. Bennett say that in his 20-plus years in Sedgwick County, he has had 1 case that he could think of where there was a speedy trial issue that resulted in a dismissal. It is exceedingly rare. In my 15 years as a defense attorney in multiple jurisdictions, I have never had a case where speedy trial was an issue. I can't even name a case from any attorney that I know, either that I've practiced with or through the State Criminal Defense Association, who has had a speedy trial case dismissed. Mr. Howe said yesterday that in normal times, this statutory speedy trial is not a problem. This does not need to be included in Senate Bill 57. I believe the proponents are unhappy with the current remedy for a speedy trial violation, which is a harsh remedy of dismissal. I would argue that this is a question for another day, but if the committee does decide to look at this issue, it's important to understand the reason for that remedy. As I said, in 15 years, I have never had a speedy trial issue, but I have had a number of clients who were innocent of their charges. Mr. Bennett talked about all those high-level cases and fear of letting those defendants go free. I am here to tell you that I have represented at least 3 people that I can think of off the top of my head who were charged with level 1s and level 3 charges who were innocent. In each of those cases, those defendants sat in jail for months while we investigated the case and gathered evidence. I can say confidently that they were innocent because they did not go to trial and get acquitted. We took that evidence to the prosecutor's office and they dismissed the charges. I'm not here to say that every defendant is innocent, but there are some, and this right is designed to protect those defendants as well as those that are guilty so that they get their day in court and they aren't languishing, waiting for a determination as to what their future will bring. Defendants are presumed innocent unless they are found guilty or unless they enter a plea on their case. I don't doubt that the prosecutors have good intentions of getting people to trial, and they've told you they don't want things to languish because evidence goes stale. They want to get things to trial. The problem is, I think that their definition of speedy might differ from the definition that a person who is innocent of their charge and sitting in jail, losing their home and their job and being separated from their family might think is a speedy trial. So an additional 60 days or 90 days might not seem like a terrible extension to a prosecutor, but it might seem like a terrible extension to a defendant. I think the state has talked about cases where there were issues of, either trial court dockets or not having witnesses available. There are currently 2 subsections in this actual current statute, subsections E3 and E4, that allow for continuances in those scenarios. They also referred to a case called State v. Queen, which was a recent Court of Appeals case. The Court of Appeals found that speedy trial was violated, and they reversed the case and required dismissal. It is currently on appeal to the Supreme Court, but I think it is worth noting that that case did not go past speedy trial because the court's docket was too full or the state was unable to get witnesses. That case went past the speedy trial deadline because the prosecutor failed to check their calendar. It's very clear from the record that's set out in that appellate case that the court mistakenly offered a date in March instead of April and asked the prosecutor, is that correct? And they said yes. I sympathize. I'm not here to say I've never made a mistake. I certainly have. It happens. But it's not because this is an impossible condition that courts are unable to meet or the state is unable to meet. It was a mistake. And in most cases, there is no issue with getting people to trial within that time frame. If there is, there are already extensions available for those specific issues like court docket crowding or unavailability of evidence. The reason that there is a very harsh remedy is because without it, there is no incentive. There is no way for a defendant to exert their right to a speedy trial. Defendants don't have a lot of power in our system. And if they want to get to trial, they have a right to get to trial because this provision exists where the case would be dismissed, so the prosecutor is motivated to get them to trial within that time frame. An example that illustrates this pretty clearly is our current preliminary hearing statute. It's 22-2902. And it provides that a preliminary hearing, which is the hearing where a court must make a determination if there is sufficient evidence to hold a defendant for trial, that hearing is supposed to occur within 14 days after arrest. I have never had a preliminary hearing within 14 days. In the jurisdictions that I have practiced in, the reality is that the defendant first goes to court on a first appearance docket. They then get set on a scheduling docket in a particular division in the larger jurisdictions. And then from that scheduling docket, it gets set for a preliminary hearing. It's rarely 14 days from that docket because the state has to have time to subpoena witnesses and the court has to find time in their calendar. There is no way to assert that right. A defendant can say, I want my preliminary hearing within 14 days, but there is no penalty if they do not receive their preliminary hearing within 14 days. And so in practicality, that right does not exist. It just does not happen. The reason that our speedy trial provisions and the remedies that they provide are important is because it provides a way to actually enforce that right. Now, I think we could talk about, are there other remedies that would be appropriate? Are there other ways that we could ensure that this still has teeth? I'm not here to say there is no other way to do that, but this provision, I think, is hasty and it's not designed to correct this COVID backlog issue. So I would urge the committee to strike that subsection. If there's a desire to reconsider that in the future, perhaps we could craft some other penalty that would still give that provision teeth. But I think that's a question for a future day. For now, I would ask that you hold off on doing anything with this bill and allow us some time to craft a more carefully worded proposal that would both protect a defendant's right to a speedy trial and ensure that the courts have time to try all of these cases without worrying about dismissals. If you have any questions, I would be happy to answer questions. And I told Madam Chair yesterday I have a court hearing at 11:30, so I asked if I could answer questions now as opposed to waiting till the other speakers had spoken.
Thank you, Ms. Glendenning. And with that, we'll go ahead and take questions from the committee members for the conferee so she can be timely in her court date. Yes, do we have a question from Senator Thompson?
Yes, thank you, Madam Chair. Thank you, Ms. Glendenning. I think it's reasonable to allow the time to get this right. Obviously, we're operating under speedy legislation. So we want to make sure we have some kind of a resolution to this. Do you feel like you're fairly close on a resolution with the proponents of this?
I think
Make sure you speak into the microphone. Thank you.
Sorry. I think that we could reach something fairly quickly. I think it would be helpful to know how quickly you need something so that we can make sure that we get you something in time.
I think that's up to the chair, but I do think we need to get this right, and it's very important to do so. Thank you.
Thank you. Yes, Senator Haley.
Thank you, Madam Chair. Respecting the boundaries of your time, Ms. Glendinning, thank you. I'm conflicted, frankly, a little bit, and certainly philosophically completely understand and agree with the representation you brought today. And I asked this yesterday of the proponents. Bail reform is something that I know several other states are considering to address this issue. If there's an easier access to release based on significant ties and what have you. Do you have any insight or recommendations as to how we might both secure the public interest in ensuring that there'll be a return to the trial by an accused through the posting of some means of bail reform that you might be aware of that others have not, and maybe some other jurisdictions are implementing?
I know that there has been a pretrial justice task force that has looked at bail reform options. In most of the jurisdictions that I have practiced in, it has been primarily cash bail. I know that the federal courts have moved away from that, and they have a fairly robust system with some pretrial supervision, and they have pretrial detention hearings on every case to determine what the appropriate conditions would be for that particular case. I certainly think that that is something that should be addressed, pandemic or otherwise. I actually was talking with my legal assistant this morning, and she was telling me about the docket of first appearances today and how many cases on that docket were traffic cases, people that were sitting in jail for traffic violations or traffic warrants because they had unpaid traffic tickets. So I definitely think there is a need to address that. I don't know that I have a solution that we could easily insert into Senate Bill 57, but I certainly hope that people look at that. And I think initially, when this pandemic first hit, a lot of people were let out of jail. At least in Shawnee County, the jail numbers went down fairly significantly. We're now back up to exactly where we were before this hit. So that didn't last. And I don't have an easy solution for you there, but I definitely wish that was something we would look at.
It's a tricky topic, and I do appreciate your opinion, your insight. Thank you so much, Ms. Glendinning, and thank you, Madam Chair.
Thank you. Senator Corson.
Thank you, Madam Chair. Do you know how many states have a statutory speedy trial right?
I wish I could say yes. What I can tell you is that I started researching this, and our Westlaw research system allows you to only search 3 individual states at a time. So I got about 10 states in before I ran out of time. Of the 10 that I looked at, which really was just starting at the end of the alphabet and working my way back, I think 6 of them had some statutory version of speedy trial. So, I mean, I can't extrapolate from that. I think it's a very good question.
We may be able to ask our research folks that question. One of the things that it strikes me is that one of the things we're worried about, here is judicial activism, and it seems like having a statutory speedy trial right in comparison to just relying on a constitutional right one of the advantages of that is it provides more clarity to the courts. It would provide more uniformity in decisions. It would eliminate the amount of judicial discretion that you would have, and where you would have one judge looking at similar facts and reaching a different conclusion as another judge with respect to whether a speedy trial right had been violated. Would you agree with that, that that's a benefit of having it being statutory in addition to just constitutional?
Absolutely. I also think that it gives people a clear deadline of what is speedy and what is not. And by having that, it gives everybody a definite timeline. And we are all on the same page. We know this case needs to be tried by this date. In various court hearings, I've seen prosecutors with these little wheels that they spin, and they put one circle on today's date, and then they go out 90 days or 120 days or however far we need to go out, and it calculates the date for them. I think that everyone is fairly accustomed to this system, and it gives a lot of definite answers, whereas a constitutional speedy trial only is very difficult to enforce. And if a defendant raises that motion in district court and says, this is not timely, you should dismiss my case. Well, the district court judge will look at that and make a record and decide whether or not they think it was timely. If they say it was timely, then it will go to trial. We will have a trial that uses community resources, calls in jurors, costs the county money. We will have that trial, and then that defendant will appeal, and they'll say to the Court of Appeals, this was not reasonable. The Court of Appeals will go back and review the record and decide whether it was reasonable or not. And they may say it was not. And we have wasted a lot of resources. We've had a lot of ambiguity as to whether or not it was speedy. And that can all be avoided by having a deadline that everyone is aware of.
And it reduces the instances where you'd have a judge in Great Bend looking at a similar set of facts and finding that speedy trial was violated, and a judge in Hutchinson looking at a nearly identical set of facts and saying that speedy trial was not violated, correct?
Yes, it would, and I think that that is a worry in many issues in criminal justice, because there are very large differences between rural counties and urban counties, or counties on the eastern side of the state and the western side of the state, and defendants with similar charges and similar situations can be treated very differently. So I think that absolutely does reduce the disparity in that decision making.
Thank you so much. Thank you, Madam Chair.
Thank you. Senator Bowers.
Thank you, Madam Chair, and thanks for being here in person, Jessica. And as lay people, I'm sure so many people don't realize that this is a big problem. So from my point of view, and I'm sure my colleagues too, that it's very encouraging to see that we all recognize it's a problem and that you're working together to find a solution for us and bringing back that idea rather than just saying no, don't accept it. It's really nice to know that we're counting on you all to work out the details and get it right for us who are not lawyers. It's very important to us, so thank you for doing that.
Any other questions from the committee? Seeing none, I want to thank you for your time, and just to let the committee know and the public know, after the hearing yesterday, did have an opportunity to talk with proponents of the bill, as well as Ms. Glendenning, and to sort of already start the process of bringing those folks together who are looking at this issue in depth and to come up with a solution that works, like you had said, to protect the rights of those who are accused, and to ensure that we timely get to trial, and we can preserve the justice system as well. So thank you for your efforts in that regard, and we'll look forward to hearing what that the outcome of those discussions look like as we have Senate Bill 57 here. Thank you for coming in person, and I think you'll then make it in time for your 11:30 court appearance.
Thank you.
Thank you. With that, then, committee, we will invite Kendall Seal of the ACLU to the podium. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. My name is Kendall Seal. I am the Director of Advocacy with the ACLU of Kansas. We are a nonpartisan, nonprofit organization that works to preserve and strengthen constitutional liberties and rights. We oppose Senate Bill 57 for the same reasons that we opposed an identical version of this bill in the House Judiciary Committee. I would like to just begin by saying we acknowledge, like I think everyone who's testified on this bill, the very real challenges faced by our courts and the criminal justice system during this pandemic, just as a threshold acknowledgement. But we do feel this bill as currently drafted is an affront to the constitutional rights of Kansans. The right to a speedy trial, as mentioned previously, in the state and federal constitutions for very good reason. Suspending these constitutional rights until 2024 will only exacerbate the systemic inequalities and racism within the criminal justice legal system. By stripping people of their constitutional rights, by stripping people of constitutional rights, we're not really getting to an answer. In fact, our constitutional rights are even more important during seasons such as these. Next, this bill will likely result in significant costs to the residents of this state and to the state itself. We've heard the government center itself in some ways in the testimony that was shared yesterday, but I want to center everyday Kansans. The costs associated with electronic monitoring and supervision will explode. As a practical matter, innocent people will languish in jail because they're too poor to pay bail. People will lose their jobs. Family budgets will be decimated by this current approach. People out on bail under pretrial supervision system will encounter disruptive and unnecessary bureaucracy to maintain compliance. This runs counter to other bills the state legislature is advancing this session to address criminal justice reform. Finally, this bill does not comport with the legislature's expressed desire to prioritize the continuation of essential government services during this pandemic. Courts have an obligation to minimize health risks to the public, which includes the risks to persons charged with criminal offenses and imprisoned Kansans. This obligation includes maintaining provisions for release from custody. Officials must consider alternative means for people to access the courts, counsel, and government offices. I'm happy to answer any questions the committee may have with regard to our position on this issue. Similar to the other opponent, we do believe this will result in significant litigation around this provision.
Thank you, Mr. Seal. We'll go ahead and reserve questions till after we've heard from all the opponent conferees. With that, then, we will next hear from Nick Reinecker, who's listed as a citizen. So, Mr. Reinecker, I believe you're on WebEx, so please introduce yourself and welcome to committee.
Madam Chair, can you hear me okay?
Yes, sir. Go ahead.
Okay. Thank you, Madam Chair and members of the committee for allowing me to speak today. My name is Nick Reinecker from Inman, Kansas. And in recognizing a National Wear Red Day and the ongoing fight against heart disease and stroke among women, I wore my red jacket not for political advertisement reasons, but for that alone. I am not a lawyer. I am just a citizen who dreamed of being a police officer and run a cafe that uses cannabis, which is currently statutorily prohibited in its recipes, for I also cook. So you will have to filter my layman errors if need be. And trust me, I would be there today, but it is Fried Chicken Friday, and when I'm done here, I will change back into my apron and attend to my duties. I oppose Senate Bill 57 as it is written. My understanding is that our country's founders put in place the Sixth Amendment as a guarantee to certain inalienable rights, and they also left it up to the states, further recognizing the 10th Amendment, to put that guarantee into their respective state constitutions and statutes. Then along came a what I believe misguided nuclear-like response by our governor and many other governors to a novel coronavirus, including quarantine and social distancing, recommendations, mandates, measures, whatever your preferred label is, based on faulty testing data and unwarranted tactical operations that has and are continuing to exponentially cause undue burden in the process of speedy trial for law enforcement personnel, judges, prosecutors, judicial support staff, corrections personnel, defendants, and of course, victims. I would be remiss if I didn't recognize the proponent from the Johnson County Sheriff's Office for their recognition that these problems came about more because of the response to SARS-CoV-2 and not the infectious disease itself. Regardless of the objective to reach 85% immunity through either natural or messenger RNA biologic means, which is mentioned in the proponent proposal portion of the Sedgwick County DA testimony, and as reported by Dr. Lee Norman on February 1st, 2021, who testified to the House Children and Seniors Committee, available for perusal from the Kansas Legislature website and YouTube page, starting at hour 1, minute 2, it is imperative that what we are labeling as speedy trial rights remain codified in state statute. Amend it? Fine. Clean up the language? Fine. Look at case law for wiser number of daily allotments? Fine. Eliminate it? No, sir. No, ma'am. Thank you. Here are my 7 opportunities of compromise. 1, carve out all off-grid and person 1, 2, 3 felonies. We know that those people are going to be probably more demanding of their constitutional rights anyway, so we can just carve those out altogether. Number 2, release from custody those discretionary middle tier cases without dismissal if this mechanism is allowed. Number 3, drop all drug cases not involving guns, physical violence, etc. Yes, this may seem radical, but if we consider the unprecedented circumstances we are told to live in and understand that those accused individuals will likely provide further opportunities down the road to prosecute them again, no heartburn is needed. Number 4, stop prosecuting anything that has to do with cannabis. Just stop it. Number 5, use statute of limitations for case prioritization. This may be obvious, so whatever. Number 6, take that 1 or 2 year deferment for crimes committed prior to the publication. Definitely not 2024. I don't really understand what that's all about. And number 7, there is a push for adding to the diversion portfolio. And so you can use your discretion and continue on working on diversion, stuff like that. Madam Chair, distinguished members of the committee, I believe the proponents here today, or that testified yesterday, and those in the room, are all honorable individuals, but it may not always be. And with the concerns and proposals floating around involving red flag laws, Second Amendment issues of temporary custody orders before adjudication, mental health parity, the Crisis Intervention Act, CCBHCs, and the state of our state Supreme Court, now is not, nor in my opinion, ever the time to eliminate statutory speedy trial rights. In my opinion, KSA 223402 is not another right, but a fortification, another layer of guarantee, an insurance policy, if you will, by the representation of Kansas citizens putting a check on potentially nefarious actors that would abuse a defendant's lack of knowledge. We are all, Madam Chair, I say again, we are all victims of this state of disaster emergency declaration proclamation, and there is much collateral damage and harm that has been caused by and because of it. Variantly, however, I do not believe this bill is an appropriate action suited for remedy, and that is why I oppose it. Thank you, and I will stand for any questions.
Thank you. And again, I want to say to our conferees who appeared today, thank you again for coming back on a second day. And with that, then, committee, do we have questions for the conferees? And committee, actually, with that, I want to point out that there is opponent conferee written testimony in your folder from Teresa Woody, Kansas Appleseed Center for Law and Justice. And I do believe there's written testimony from our opponent conferees in your committee folder as well. Do we have any questions then from the committee for our conferees? Seeing none then, thank you again to our conferees, both in the committee room and on WebEx for appearing today. And it has been a robust 2 days of hearings on this issue. And it's an issue that will be further looked at by both sides of the issue, I would say, and they'll hopefully work something out that we can take a look at then as a legislative body. Committee, I do want to point out, we don't have any neutral conferee testimony in your folder, but do want to make a call for, are there any opponent conferees either in the committee meeting room or online? Seeing and hearing none, do we have any neutral conferees either in the committee meeting room or online? Seeing and hearing none. Again, committee, direct your attention to the written documents in the committee folder. And with that, then we will close the hearing on Senate, oh, excuse me, we do have a question. Yes, Senator Haley. Yes, there is written testimony in your committee folder from Mr. Reinecker. Great. Okay, then. And again, for those of you following online, you can find that on the ks.legislature.org website. If you'll go to the committees tab and Senate Judiciary, and on that page, if you'll go to the miscellaneous tab under the agendas tab on that page, you'll be able to find the PDFs of the written testimony. And with that, then, we will close the hearing on Senate Bill 57 and want to bring the committee and the public's attention to our agenda for Monday, February 8th. Monday will be the final day for individual bill requests for introduction in this committee. And also want to note that Senate Bill 141, enacting the Kansas Uniform Directed Trust Act, will be ready for hearing on Monday. That was added to the agenda, having been finalized and ready for hearing Monday, February 8th. So please be ready for those. And with that, then, we will be adjourned. So thank you, committee, except for one question from Senator Thompson.
One quick question. Sorry about that, Madam Chair. Yeah. I've had a number of constituents who have contacted me. They've been receiving 1099s from their unemployment, and the amounts that are on the 1099 do not match up with what they received. In some cases, in many cases, the 1099 indicates there's more money that they received than they actually did receive. And we're a little bit concerned that there may be something going on, and would ask if we could have legislative research contact the Department of Labor and look into these disparities. This is not a one-off. We're getting a number of these requests and concerns into our office. So we want to ensure that, you know, somebody, there's not some, not accusing anybody, but that there's not some fraudulent things going on, you know, somebody hacking into accounts. I would just like some resolution of this so we can help our constituents, and I would appreciate that, Madam Chair.
Thank you, Senator Thompson. It's a good point, and it's a good question. I'm receiving those kinds of questions as well. So I would ask if we have Natalie Nelson from Kansas Legislative Research Department on WebEx. Is that something you can look into on behalf of the committee?
Yeah, Madam Chair, I'm here. Yes, I can look into that and see what I can find.
Great, thank you. Then we'll look forward to hearing the results of your research and looking into that. And I think that ties in nicely to what the committee was looking at earlier this week, which would be Senate Bill 60 that we heard regarding defining proximate result for purposes of determining when a crime is committed partly within this state. We did hear from Conferees that with Senate Bill 60 that would allow some further definition for the state when an out-of-state bad actor, if you will, hacks, for lack of a better term, into a Kansas resident's computer or steals identity or something of a Kansan, that we have then more teeth, if you will, to prosecute those types of crimes when the resulting harm, when the victim is here in Kansas. So that would be worthwhile, I think, for our legislative department to take a look at for us, and maybe get those results back as we think about Senate Bill 60 and possibly working that. So thank you for bringing that up, Senator Thompson. Appreciate that. Any other comments from committee, or without any, then we will be adjourned. Thank you very much.